come on down, or come on back. I've got you. I think we're good. We've got someone standing in for Attorney Cataldo. Oh, you know, is anyone standing in for Attorney Tipton? That's standing for Attorney Tipton. Is he coming?
I thought he actually just sent me something. He said,
yeah, you did. Okay, then.
So he might be on Zoom. Is he not on Zoom?
No, but then we're not ready.
Okay.
Sorry.
Come on.
I'm just.
I'll text him right now and see where he is.
Okay, fake news. I mean, it's technically not late yet.
Can I get that to you? Okay.
Okay. Yeah, I think. No. Well, it's like I listened to someone else and I didn't verify. It's my fault. Okay. So, Assistant Chief Carlo, can I have that guy actually? Yes. I don't know if we have time to do that tomorrow.
Can we do sidebar?
Yeah, of course. Human? So, makes me feel a little better that you feel it too.
I do.
Here. That was so fun.
Ready whenever you're ready.
We're ready, right?
Ready for Mr. Castellino.
Sorry? You got it. Leave it at the front door. Okay.
He's coming out right now.
Oh, okay.
Sorry. That's why I. Good afternoon.
Just coming out to your phone, going in,
No.
Not on Zoom?
No.
Work, all right.
Hey.
Okay.
anticipated, put it in session.
We're going to start with number 13.
Okay.
Commonwealth versus Francis Castellino, 25 CR 73. Mr. Castellino is present and represented by Attorney John Brinkman. The Commonwealth is represented by Assistant District Attorney Amanda Mullaney. The matter is on for hearing on a non-evidentiary motion to suppress. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Amanda Mullaney for the Commonwealth.
Okay.
Good afternoon, Your Honor. John Brinkman from Mr. Castellino.
Okay, Mr. Brinkman and Mr. Castellino, if you want to be seated, you can, okay? I didn't see any motions filed.
There was no motion filed, Your Honor. In speaking with counsel today, I had not realized the reason he did not file the motion on the search warrant, but not the search warrant itself. So I am working to correct that and get him the search warrant.
Okay. So you don't even know if you're going to file a motion.
I will be filing one.
Okay. What's the schedule? What schedule makes sense?
I can get it to him today or tomorrow.
Today or tomorrow. So you're going to file it by when? End of the month?
Yes, that's fine. The problem is I've got...
And not the end of this month. That's tomorrow.
Right.
So do you want a date for a hearing in December?
If we could go into January, I've got a trial down in Fall River that's going to go for the entire month of December.
Okay. So you want a date in January for a hearing?
Yes, please.
But you're going to file by the end of November?
Yes.
Okay. So filing of any motion to suppress by November 28th, that'll be reflected on the docket. And we'll give you a hearing date, January 8th.
That's good.
Is that okay? That's a Thursday?
Thank you.
All right. Okay. Anything else?
That's it.
No, thank you.
Okay, very good.
Mr. Castellino, your matter is continued to January 8th at 2 p.m. for hearing a non-evidentiary motion to suppress. The motion must be filed by November 28th. Thank you.
Thank you, Madam Chair. Thank you, Your Honor.
We do have Mr. Tipton on Zoom. Attorney Tipton, can you hear me?
I can.
Thank you. Okay, so we are going to call Mr. Johnson, Mr. De Los Santos, please. Number 1, Commonwealth versus Miles King, 21 CR 320. Mr. King is present and represented by Attorney Rosemary Scapicchio. Also before the court, Commonwealth versus Bianca Cianciancio, 22 CR 265. Attorney Corey Madeira is here for Joseph Cataldo.
Good morning, Your Honor.
Afternoon.
Also before the court, Commonwealth versus Giovanni De Los Santos, 22 CR 267. He will be entering the courtroom momentarily and is represented by Attorney Joseph Krowski Jr. Also before the court, Commonwealth versus Sean Johnson, 22 CR 268. Mr. Johnson will be entering the courtroom momentarily, is represented by Attorney Rosemary Scapicchio. And finally, number 6.
Good afternoon, Your Honor.
On the list is Commonwealth versus Brian Walshe, 23 CR 91. Mr. Walsh's presence was waived by his attorney, Larry Tipton, who is on Zoom. The Commonwealth is represented by Assistant District Attorneys Lisa Beatty and Jennifer Hickman. Matters are on for status. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Lisa Beatty for the Commonwealth.
Okay.
Good afternoon, Your Honor. Jennifer Hickman on behalf of the Commonwealth.
Thank you.
Good afternoon, Your Honor. Rosemary speaking on behalf of Mr. King and Mr. Johnson.
Thanks.
Good afternoon, Your Honor. Nicole Scapicchio on behalf of Mr. King and Mr. Johnson.
Okay.
Good afternoon, Your Honor. Attorney Corey Madeira on behalf of Bianca Cianciancio, who is present today. Filling
Okay.
in for my colleague, Attorney
Can you just spell your last name for me?
Madeira, M-A-D-E-R-A.
Okay.
Judge, Attorney Joseph Krowski Jr. on behalf of Giovanni De Los Santos.
Thank you.
Glenn Tipton on behalf of Mr. Walsh.
All right. You are very faint to hear, Mr. Tipton, again remotely, but I heard that you're representing Mr. Walsh.
Yes, Your Honor.
Oh, no, I'm not. Sorry, I forgot it's not my audio.
That's not good. Yeah. Okay. Gentlemen, you can be seated.
Have a seat. Mr. De Los Santos, have a seat.
Okay. We're here for an update.
Your Honor, from the Commonwealth's perspective, Nothing has changed since last week. We believe that we have complied with Rule 14 and our obligations, and we intend to comply with Judge Casper's order and return and destroy materials tomorrow morning. I have my phone out, and I apologize to the court, but I know that Mr. Tipton filed a motion at around 12:30. I don't have it in hard copy, so I'm going to have to review it on my phone. I don't have any other pleadings from...
I'll give you a hard copy.
Oh,
I'll give you my copy.
Thank you. Oh, great, thank you.
You have it. Okay. Should we put this on for a second call?
No, I think that I'd prefer to, it's somewhat bare bones, the motion, so I think that at this stage, Mr. Tipton ought to argue first.
Okay. All right. Is there any other issues with respect to Mr. King, Ms. Chinchillo, Mr. Johnson, Mr. De Los Santos?
May I, Your Honor?
You may.
On behalf of Mr. King and Mr. Johnson, Judge. I have had a number of conversations with the Commonwealth trying to work out what's remaining out of the federal materials before they are destroyed tomorrow. It was my initial position that if the Commonwealth, there are certain grand jury minutes that relate to the Karen Reed case that we're looking for that are both in the custody of the federal government and in the custody of the Norfolk County District Attorney's Office, as well as some police reports that relate to the Karen Reed case that involve officers that are also either in the Johnson or the King matter. And so we initially had talked about whether or not we would file Rule 17 motions for that information if the Commonwealth wasn't willing to give it to us. I think the Commonwealth is taking the position that if we can justify it under Rule 14, that they would give it to us under Rule 14. And I think, and you can correct me if I'm wrong, that if it wasn't a Rule 14, that if we ask for it under Rule 17, that maybe the agency objects, but I don't believe the Commonwealth would object under those circumstances. I just want to make sure I'm clear about that, because we've been going back.
This is not an issue in front of me. The only issue here is the issue of the federal materials and what's going to happen to the federal materials.
Right, well,
so you can work out whatever you want with Attorney Beatty or the attorneys prosecuting Mr. King or Mr. Johnson.
My concern, Judge, is I don't want to say I don't have any objection if I'm not going to be able to get the information from the Commonwealth. That's the whole point.
Which information are you talking about? Are you talking about the federal materials or are you talking about other materials?
The materials that are listed as federal materials, which include state grand jury and police reports.
State grand jury is not federal materials. State grand jury is in the possession of the DA's office.
Right.
Right, and that's not being returned. So the question is federal materials. Is there an issue with respect to the return of the federal materials?
So those state grand jury minutes and the police reports are listed as federal materials, Judge.
What am I missing, Attorney Beatty?
I don't think you've had the opportunity to review the index, and so that's why you have less information than the parties do. So I think the best way to explain it would be that state grand jury minutes, which the Commonwealth produced in discovery to the defendant in Reed, also became federal materials, which were reproduced to us. So we have them independently, and if a defendant filed a Rule 14 for state grand jury minutes or for police reports in the Reed case, we would evaluate that because we have those materials in our possession, custody, and control.
Right. So
separate from the federal materials.
Right.
So I agree with the statement that Ms. Capiccio made about the state materials that we have complete control over.
Okay. So I don't consider those federal materials. The federal materials are materials that only the feds have control over and that are exclusively covered by Judge Casper's various orders. And the question is whether there's any obstacle to the return or destruction order, which it has to happen by tomorrow. And I've gotten nothing from you in writing, right?
No.
Okay. Okay. Does anybody want to be heard on the issue of destruction or return, other than Mr. Tipton, who's filed something? Okay. All right. So, fine. Mr. Tipton, do you want to be heard on the issue of return or destruction of the federal materials?
Well, I think I laid out the bare bones arguments, Judge, if you can hear me. I've laid out the bare bone arguments.
Hang on one second. I can't really hear you, and I bet Attorney Beatty can't hear you, and I bet the defense attorneys can't hear you who are arrayed in court. So, sorry, Margaret. Mr. Tipton, can you do any better?
Well, I've got my volume all the way up, and I'm sitting close to my microphone, so I don't know.
I'm going to allocate $10 of funds to buy you a microphone or something. This has been a persistent problem, Mr. Tipton. Maybe CPCS can spring for it.
I'm happy to call him on my cell phone and put it next to a...
All right, let's try that. We're going to get you on the cell phone.
Larry, I'm going to call your cell.
All right.
Just mute yourself now. You'll be on video. I'll be able to see you, but we'll work on the audio connection via cell.
I don't do this.
Attorney Tipton, I can mute you.
I'll take the phone.
All right.
Promise to return it. All right, Mr. Tipton, are you able to hear us?
I can hear you. Can you hear me?
Yes, I can. Let's try that again. Can you identify yourself for the record?
Larry Tipton for Mr. Walsh.
All right, is everybody able to hear that?
Yes, Your Honor.
Okay, very good. All right, Mr. Tipton, go ahead. I've read your motion. It is very bare bones.
And basically what it's saying, Judge, is what I've been trying to say for the last few weeks, is that if you allow the destruction of these documents that we have never been able to review in their entirety, we lose the opportunity to ever review them, and it certainly would prejudice the defendant, my client, in the event of an adverse verdict, for there to be an appellate record to review with regards to what's ever contained in those documents. And without breaching the protective order, I can only say that having reviewed what was provided now, pursuant to the protective order, I completely agree with the Commonwealth that what they produced was favorable to the defense, and it gives me reason to believe that other documents that are contained in what's called the federal documents may very well contain favorable evidence if it was reviewed by a defense counsel that's familiar with the facts and circumstances of his case. And that's what we're doing here. And so for the reasons I state briefly in the motion, that the Declaration of Rights has often been ruled to provide more protections in the context of defendants' rights in Massachusetts, I would ask on behalf of the Declaration of Rights and on behalf of Mr. Walsh that the court order that the Commonwealth maintain a copy of all the documents they have, notwithstanding the order of His Honor Judge Casper.
All right, Attorney Beatty. Before I hear from you, Mr. Tipton, I have a essentially three-page motion from you. It certainly says that you agree that documents produced to you were favorable to the defense. I didn't read it as saying that it gave you reason to believe that the Commonwealth had other materials that hadn't been produced which were also favorable to the defense, or even that you might come to a different conclusion than the prosecutors came to with respect to the federal materials. And I don't have an affidavit from you, and I don't have any description of any of the materials, which could be provided to the court under a motion to impound that could have been sealed, identifying a single document that would fall into that category of favorable to the defense but not produced. So I'm not quite sure how you expect me to grapple with this extraordinarily bare bones affidavit that's not supported with, bare bones motion that's not supported by an affidavit.
I will, if the court will accept it, I'll file an affidavit by the close of today, and I'll file it under seal, and I'll lay out what my specific thoughts are based on the review of what's been provided.
Right now, I don't have enough, for sure, to issue an order contrary to Judge Casper's destruction order.
I'd ask that be done within 45 minutes, Your Honor. We have had this date for well over a week. There is an index, which I'm going to ask the court to consider as you're making this decision, that Mr. Tipton has. And certainly he could have filed a motion under seal that had more specific information in it, but we do not have time. The Commonwealth has continually been faulted for taking its time. But I would ask that be filed by 3 o'clock. I will wait, and then we can have further hearings on this today.
Mr. Tipton?
Yes, Your Honor.
Did you hear what Attorney Beatty was just just saying?
Yes, I did, Judge.
Okay. Can you file something today?
I certainly can.
Okay.
But I heard her say 3 o'clock, and I will do everything I can to get it filed by 3 o'clock.
We'll put this on for a second call. We'll put the Walshe matter on for a second call, and we'll go through our list, and whenever we can get back to this case, we'll get back to it. Whatever you file, make sure you email to Ms. Sannel.
Judge,
I certainly will, Judge.
Okay, Mr. Krowski?
Sure. On behalf of Mr. De Los Santos, I appreciate that Mr. De Los Santos is not a co-defendant of Mr. Walshe, but certainly there's a consolidation of litigation. So I would prefer that my client too have a second call, because I would join any relief that the court grants to Mr. Tipton and his request.
There's been no consolidation of litigation. We've been having these hearings jointly because they involve a common issue. But I've got nothing from you suggesting that anything in the materials relating to your client is problematic or hasn't been produced from the federal materials. So you're welcome to stick around, but I'm not going to hold either your client or Ms. Capicio's client here for a second call, and counsel is welcome to stick around if you want. Okay? We'll put this on for a second call with respect to Mr. Walshe.
I did have two motions that don't have anything to do with Mr. Tipton.
And so I'll take them up in the ordinary course. Has your client been interviewed to determine indigency?
I don't believe so, Judge.
Okay, so your client needs to be interviewed, and that'll include information about what's been paid so far and things like that.
Yes, Your Honor. Can I approach sidebar on that?
Can you approach sidebar on it?
Yes.
No, we need to have an interview first, and then I'll take these under I'll take them under consideration. Okay.
Yeah. Can they be interviewed by probation today, Judge?
We've got a long list. I don't know if probation can or can't. Mr. Tipton, I'm giving the phone back to Ms. Capiccio.
Want to be one?
No.
Sorry, I'm hanging out.
Judge, I also, prior to, I know you're not going to give my client a second call, but there is a pressing matter I'd like to address at sidebar with the court and Commonwealth.
Okay.
If we could?
Yeah.
Okay, so second call?
And if I may, Your Honor, Jennifer Hickman on behalf of the Commonwealth. In regards to Miles King, Your Honor, I believe that is not getting a second call, but we do not have a next date. The Commonwealth, at the time that it filed, I believe on October 4th, the Commonwealth filed 2 Rule 17 motions. We're asking that they be put on for argument for December 4th at 2 p.m. I know Attorney Capiccio has a homicide trial starting in Suffolk County that she anticipates will go 3 weeks. So we're asking for December 4th for argument on those Commonwealth Rule 17 motions.
That's fine.
Thank you.
Thank you, Your Honor.
Ms.
do we-
Chantio also?
No, this is only for Miles King.
Just,
Okay.
This is purely for Miles King, who,
do we have next dates on the other cases? So let's just run through them. We do now have a next date on Mr. De Los Santos. What about Ms. Chanchicchio?
I don't believe so. I think that Johnson and Chantillo need another date.
How long is it going to take for the second round of information?
We're hoping that we'll be able to produce that by the end of the week, next week.
So could we put that as well on for December 4th at 2?
Certainly.
Would that be?
Johnson and Chanchillo?
Yes, Judge.
If that's okay.
Mr. Madero, what do you think? I think she should be here, okay? I will not waive her appearance, so.
And,
2? I'll move some things around.
and Judge, if I could, with respect to Mr. King, he can see probation whenever they have time for him, but Mr. Johnson, if he goes back and doesn't see probation, he won't be able to fill out a form till the next time he's here, which would be December 4th. And the information.
If we can get him interviewed today, we'll do it, but.
I'm not looking to put any additional burden on anyone. I'm just saying, to the extent that we could get it done today, I'd be looking for access to those funds so I could give the court an update on where we are in terms of looking at the personal phone.
We'll see. I mean, we'll see if we can get him interviewed.
Thank you, Your Honor. I appreciate that.
Okay.
December 4th, and the second call on Mr. Walsh.
Thank you.
While we're clearing out this,
Oh, okay, no problem.
we have Ethan, oh, yeah, sorry. Can we have Mr. Lynch?
Quiet, please, quiet, please.
Okay.
Coming up.
Let's see this. Is this?
So next before the court, number 5, Commonwealth versus Christian Lynch, 23 CR 24. Mr. Lynch will be entering the courtroom momentarily and is represented by Attorney Ethan Yankowitz. The Commonwealth is represented by Assistant District Attorney Elizabeth McLaughlin. The matter is on for a motion hearing. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Beth McLaughlin for the Commonwealth.
Okay,
Ethan Yanklowitz for Mr. Lynch.
okay. So he hasn't entered the courtroom yet, but is there an opposition to a 15A?
There is.
Okay.
I'll be brief.
Okay, Mr. Lynch, before you came in, the lawyers identified themselves for the record, and that was pretty much all we did. Since we were here last, I received a motion filed, I think today or yesterday, by the Commonwealth asking for an evaluation of your competency to stand trial, and I wanted to hear from Mr. Yankowitz as to what his views were on holding such a hearing.
Thank you, Your Honor. Ms. McLaughlin actually filed this a few weeks ago. I've had an opportunity to discuss this with Mr. Lynch. On his behalf, I would object. I don't have any present concerns about his competency. I'll say it again just because there was some talking in the courtroom from the radio. I don't have any present concerns about his competency.
Okay. I had concerns. I was glad to see the Commonwealth filing this after I had a colloquy with Mr. Lynch about whether he wanted to waive his right to a jury. I had similar concerns to what the Commonwealth articulates in its motion. I do see it was filed, or it's dated October 10. I didn't see it until today. Had I seen it earlier, I might have arranged to have a medical person here to do an evaluation. It does seem to me we need to get that arranged. So what I'd like to do is put this on for a 15A evaluation sometime next week, and we can arrange for a medical person to be here. They could do the evaluation in the morning, and we can call the case in the afternoon, depending on your respective availability.
Yes, I think the earlier the better from my perspective and Mr. Lynch's, since we have a trial date of December 1st.
Okay. I could do Tuesday. I have an all-day hearing on a motion for new trial, but I can interrupt that at any time to take this, meet with the doctor, hear what the doctor says, if he's able to do the evaluation. The only question I have is whether that gives us enough time to arrange a doctor to be here.
Is there any way, Your Honor, that we could do either Monday or Wednesday? I'm unavailable on Tuesday.
You're not available Tuesday, okay.
I can try to switch around my schedule, but if we did it, I would prefer Tuesday. I would prefer Monday or Wednesday if that is possible.
Sure. I could do Wednesday. We're going to be either on trial or impaneling a jury on Wednesday in the morning. But we can put this on for 2 o'clock and make sure the doctor's here in the morning so the evaluation is done whatever time the doctor needs.
I'm here that day.
Okay.
I can, and I will to the Dr. Burke, let you know that if, unless there's a 15A order, they don't want people to be on standby, really, so.
Okay, so I'm going to allow this motion for a 15A to be held, to be conducted on the.
I will email on this.
What would it be, the 5th?
But Mr. Lynch will be coming at 9, and I should be here at 9, and the doctor, if available, will be here at 9?
Do like 11, and then he can report usually right before 1.
Sure, that'd be fine.
Okay.
So should I be here before 1 or at 2 o'clock?
1.
Great.
That works for you.
Yes.
And it's just competency?
Yes. If there is a specific form that I need to sign on this, you can let me know, but I've endorsed it. Okay? All right, we'll see you Wednesday.
Thank you.
Thank you, Your Honor.
November 5th at 11, 15A. Thank you. Mr. Kiernan, have you heard from Mr. Sampaio?
Yes.
Okay, great. Next before the court, number 8, Commonwealth versus Robert Sampaio, 23 CR 237.
Okay,
matters
great.
on for probation report. Amanda Mullaney for the Commonwealth. Do we need Bob Nelson? I didn't see him. Okay. Okay, so then I guess I'll have to do a second call. Sorry about that.
Bear with us.
If we can get Mr. Nelson, we'll. Next before the court, number 9, Commonwealth versus Rocher Sorrell, 23 CR 303. Mr. Sorrell is, I'm not sure. He is represented by Attorney Karen Wayne. Is your client here, Attorney Wayne? And the Commonwealth? Okay. No. And Courtney Kiernan? Okay, do we have Courtney Kiernan? I thought she was just here too. Oh, there she is, yep. Everybody's here. Okay. And the matter is on for a lobby conference. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Courtney Kieran on behalf of the Commonwealth.
Okay, thank you.
Good afternoon, Your Honor. Karen Wayne on behalf of Mr. Surreal, who's present before.
Okay, Mr. Surreal, you can be seated if you want.
Good afternoon, Your Honor.
Okay, good afternoon. Ms. Wayne, the case is on for a lobby. I don't know if you want to lobby the case?
Well, I think we've come to, in my opinion, a rather good agreement so far. So, I would just like a date in, late January for change of plea.
You have an agreement? I'm not going to put it off till late January.
Well, December's pretty well booked, Your Honor. I haven't got a lot of time left in December.
We got no problem putting it on for a date that's convenient for you, Attorney Wayne. What is the agreement?
The agreement is, well, I'll let my sister.
It would be dismissal of number of charges.
Which charges would be dismissed?
So large capacity firearm charges that carry the more significant mandatory minimum, a plea to carrying 18 months in the House of Correction with 2 years probation from and after on the
Is it a plea to 10A, 18 months in the House?
Yes.
Okay, 18 months in the House, yeah, go ahead, sorry.
2 years probation from and after on the assault charges.
Okay. And what about the B&E, burglarious instruments, receiving stolen property, larceny over $1,200?
So the actual B&E would be dismissed, the receiving would be the probation.
I'm sorry. The actual B&E would be dismissed.
Yes.
Receiving would be probation, okay? Just trying to keep score here. Okay? Burglarious instruments, larceny over?
Those would be dismissed as well.
Ms. Wayne, does your client have any time in custody, any credit?
He has, yes, Your Honor, he did do a revocation.
I don't know if that's credit.
That's,
Do you have an agreement that that'll be credited?
We don't.
no. We haven't talked about that part, Judge.
Okay.
But it wouldn't go to the 18 months mandatory anyways.
I beg your pardon?
I don't think it will go to the 18 months mandatory. Isn't that a full 18 months he would have to serve?
It is a full 18 months, but if he's getting credit for the revocation time, that would go against the 18 months,
Okay.
right? But
They get credit. How much time did you, 6 months? He was in jail 6 or 7 months. I don't remember at the top of my head whether it was a 58A or was a revocation.
all right.
We'll talk about that.
I'm happy to pick a date in December.
Well, the reason why I wanted January, he just became a new father and he's got 2 other children. He'd like to spend Christmas with his family. That's why I was hoping for a January date. But it involves jail time.
But then he's going to want Valentine's Day too.
No.
All right, January 7?
January 7th is fine.
The other option, I think I'm more inclined to do this,
Okay.
is take a plea sooner rather than later and impose sentence on January 7 or a date after Christmas.
That would be fine.
So what date would be convenient? I want to make sure that, otherwise we'll set a trial date now, and I don't want to.
I
I'll work
can
it
do, anything, the 15th, the 16th, the 22nd, the 23rd.
Oh, you got a lot of availability in December.
Yes.
15, 16. All right, how about the 15th?
15th sounds fine to me.
15 works for me as well.
12:15.
15 at 2 for a change of plea, and put over sentencing till after Christmas. Okay?
Yes. Okay, Mr. Walshe, your matter is continued to December 15th at 2 p.m. for a change of plea. Thank you.
Thank you.
Okay?
What's our fee? Talk about.
And the parties on 10, Ms. Melker is in the office, and the witness. Let's talk about friendship. That's very fun if you're not in a trial. He wasn't jailed.
So they are definitely going to be a trial?
Yes, but not getting that high.
Mm-hmm, okay. I'd like her to say that on the record. I think you should call her. Are they here?
Oh, I think they
They left, okay. All right, it's okay.
I can try to catch them.
Yeah, it's okay.
Next is for the court number 11, Commonwealth versus Michael Hickey, 24 CR 19. Mr. Hickey is, I think, in lockup.
He was not brought in.
Oh, no.
I don't know that we need it necessarily.
Do we have Middlesex on Zoom? I don't think so. But, if you could just identify yourselves for the record.
Good afternoon, Your Honor. William O'Driscoll, the Commonwealth.
Afternoon, Your Honor. John, give me some behalf of.
Okay. We were good to hear a motion, but your client's not here?
But it seems like, yeah. So we actually talked, there's a warrant that's outstanding. We're gonna ask that that be removed and he be released to a sober house. I think that's by agreement. And we can then schedule the motion.
I'm not doing it without him here.
Your Honor, today's the 90th day of his revocation.
That's nice.
The warrant is from this case.
So he'll have to be brought in here on the warrant, and then we'll set bail. We'll set conditions.
Is he still in Middlesex?
Yeah, he's on Zoom. They said that he was supposed to be brought in. There's a Hague for him to get here.
Yeah, there is a Habe.
Yeah, and
It does not have Zoom information on it. It says please transport.
Do we have somebody from Middlesex on Zoom?
Everyone has pretty much has their name. There's nothing that looks.
Nothing, okay.
So I don't know why he wouldn't have been brought in.
I don't either.
We could have him habed in for tomorrow morning. I'm happy to see you tomorrow morning. We can have the hearing tomorrow morning, but,
that's the guy from the halfway house.
Oh.
if we're going to release him, we got to read them as bail warnings. There's a raft of things we have to do, and I'm not going to argue the motion without him being here. I'm not going to hear argument on the motion without him being here.
Tomorrow morning, fine.
Okay?
Okay.
9 o'clock?
Can we make it a little later, maybe 10:30?
How about noon?
Fair enough.
Okay. Okay.
Yeah, noon.
Okay, there's somebody here from the sober house. I've just been handed a bunch of papers. Have you seen these papers?
Yeah, I have that information.
Have you seen these papers, Mr.
I believe
O'Driscoll?
Mr. Gibbons gave me a copy this afternoon.
Okay, this is something relating to Harvard House in Quincy?
That's correct.
Yes.
Okay.
I might as well put that up there too, that's stuff from the jail, the same stuff behind it. He's gonna look at it, I don't know. That may be for tomorrow morning too. It's information from the jail, the program that he's been in, that he's completed.
Okay, great. All right, sir, you are you're from Harvard House?
Yeah, good afternoon.
Okay.
My name is Mike Gash. I'm the owner of NASSoberliving.com in the Harvard House, and I'd just like to just say a few words on Mike's behalf, you know.
Now would not be the time, I'm afraid. I appreciate your being here. I'll hear from counsel tomorrow when we have Mr. Hickey present, and we can have a fuller hearing. Okay, I'm sorry you can't be here tomorrow. I'll consider the stuff that you've submitted.
Thank you.
Okay?
Thank you.
Anything else?
Oh, you're on.
All right, we'll see you tomorrow at noon.
Thank you.
Thanks again.
And we should make sure that Abe is for early morning, since he's coming from Middlesex.
So see you tomorrow at noon.
wait till tomorrow. Yeah.
Is Mr. Blunt going to be a plea?
No, it's on for, submitting motions. I have.
Okay. Next before the court, number 12, Commonwealth versus Trey Blunt, 24 CR 101. Is your client present? Attorney Babcock, is your client present?
No, he is on the way, Your Honor. However, I'm looking just for, I have motions to file with Your Honor, if I may. I have the motions to dismiss I discussed, the motion to suppress I discussed on our last date. I also have a motion for a firearms expert to inspect the firearm in this particular case. I also have had, I think, significant discussions with my brother about possible resolution, and I have prepared a breakdown memorandum that I think I'll complete in the next few days. Based on that and based on my conversations, lengthy conversations with my client, I think that the most advisable thing to do would be select a lobby date and possibly resolve the case that way if it's amenable to the court. And if that doesn't work, then proceed with the motions.
Do you have an agreement?
No.
I'm waiting on a packet that would be involved some breakdown in regard to the trafficking charge. I don't know if there would be a breakdown on the firearm charge, but there are some mandatory minimums the council needs to address with at least a packet, which he said he'd provide for the next date or prior to that date.
And I have had, since the last date, lengthy discussions with my client. He's come to my office. I've gathered a lot of information for a breakdown memorandum. I'm close to finishing it, so I anticipate getting that into the Commonwealth in literally the next week or less. So if we had a potential lobby date in December, I think that would give the Commonwealth time, hopefully. I don't want to rush the Commonwealth.
You filed the McCarthy motion?
Yes.
Did you file the grand jury minutes?
Oh, so I have his affidavit in support. I did not file with it the grand jury minutes.
I need the grand jury minutes. That's all I need.
Absolutely, Your Honor. So
maybe the grand jury exhibits.
So my intention, Your Honor, was to file, when I file my memorandum, to file the grand jury minutes as an attachment to the memorandum.
I want the memorandum. The motion doesn't do me any good. I need the memorandum too. Okay, I need everything that you're going to file as one package.
Absolutely, Your
So
Honor.
when are you going to file the memorandum?
It's 90% done. I could.
And what about the motion to suppress? Are you intending to file a memorandum with that or not?
Yes, Your Honor.
When are you going to file that?
Both of them are almost done. I could file them in 2 weeks. Particularly in the motion to dismiss, I think, get fairly in-depth in the motion to dismiss about the legal underpinnings in the case, but I obviously need a memorandum.
Okay. What do you think?
Sure, I did just receive the two motions. I'm happy to attach the grand jury minutes to my response, for Your Honor. I'm wondering if it makes sense to pick a date just after 2 weeks for lobby as well as filing for those motions, and then we can pick a motion date if the lobby's unsuccessful.
That makes more sense to me than kicking this into December.
That's fine, Your Honor. I would want to give my brother ample time to review the motion with his office. So that was my only thought about, giving it, a 2-month date. But if my brother thinks that if I get the sentencing memorandum in the next week or so, maybe if we could have just a 30-day date, I guess. Or.
Well, you're going to get it to him in the next week. How about November 14th for a lobby and to set other dates? Your client will have to be present at that date, on that date.
Absolutely, Your Honor. Could I just ask for either the 17th or the 21st? I'm in Middlesex on the 14th.
17th is fine.
That works.
I'm sorry, November 17th?
November 17th for a lobby and to set dates for hearing on various pending motions.
And so, Your Honor, I'll have the sentencing memorandum to the Commonwealth by the 6th, November 6th, and I'll have the memorandum to file on those dates. Is that?
Okay. All right. And we'll take up all the motions, including the inspection of the firearm on the next date.
So, but that's acceptable to Your Honor to file the memorandum on the next date and select a motion date if necessary?
No, I thought you said the memorandum was going to be filed on the 6th.
Oh, sorry, the sentencing memorandum for the Commonwealth on the 6th, and then the memorandum in support of the motions on that date.
That's fine.
Thank you, Your Honor.
Okay.
I thought there might be confusion.
We're on for November 17.
Thank you very much, Your Honor.
Thank you, Your Honor.
Okay, is the Commonwealth asking me to do anything with respect to Mr. Blount's failure to appear?
No, Your Honor, he's appeared at every date.
Okay.
And we met in my office literally, I think, a couple weeks ago. He's been on board. When I texted him, he said he was on the way, so.
It's 50 minutes after when he was supposed to be here.
I appreciate that, Your Honor.
Okay.
Thank you very much, Judge.
We'll see you on the 17th.
Oh,
At 2 p.m. Thank you.
thank you very much, Judge.
Martinelli, you can stay put for a second. Next before the court, number 15, Commonwealth versus Charlman Dowell, 25 CR 136. Mr. Dowell is present, along with his attorney, Mark Bennett. The Commonwealth is represented by Assistant District Attorney Joseph Martinelli. The matter is on for a pretrial conference. If the parties could please identify themselves for the record.
Good afternoon, Your Honor, Joe Martinelli, Commonwealth.
Okay.
Good afternoon, Your Honor. Mark Bennett for Mr. Dowell. He's
Okay.
present.
Mr. Dowell, if you want to be seated, you can. You don't have to stand up for the whole thing. All right. Well, where do you stand in terms of discovery?
There are a couple items of discovery that were in the federal custody, Your Honor. I did on the last date turn over several search warrants to counsel. Since that time, I was able to receive the results of those search warrants on a thumb drive. I'm going to make a copy and provide that to counsel forthwith. I also received the grand jury transcript that I did just email to counsel. And counsel indicated they're looking for the search warrant, not from the federal agency, however, from the Randolph Police, which I do have a copy, and I'll send that to him by email today.
Okay. So you feel like you're pretty much done with discovery, or what?
I believe so, unless there's anything else with the federal chain of custody on the items that went there for testing and come back. If there's any
ballistics went to the feds for testing?
The ballistics went to our state lab for the firearms, and for the magazines, there were a series of Glock switches that went to the federal lab, I think in Virginia.
But all those lab packages have been produced?
I have not received them back yet. Those would be
That stuff hasn't been produced?
That would, yes, that has not been produced.
Phone went to the feds as well.
And that would be the subject of the search warrant, the federal search warrant, which the documents related to the extraction, as well as those warrants, I have those.
Okay. So what should we do next?
Oh, let's say I'm an optimist. How about if we say December 12th for the filing of motions?
Okay. Discovery motions you're talking about, or potentially, suppression motions?
Well, I smell a motion to suppress coming along.
Okay.
And perhaps I can have it ready by then.
Okay. What date would work for you?
December 12th, does that work?
That's a Friday. It's okay with us? I believe.
That works.
12th is okay, yeah.
And, Your Honor, would you consider excusing Mr. Dahl from appearing that day? He's working and he has to take off to be here in the afternoon.
Any problem with that, Mr. Martinelli?
No, Mr. Dahl has appeared at every day.
Okay, very good. Yeah, you'll be excused from the next date, December 12th. That'll be for filing of motions?
Yes.
Which means at that time, Mr. Dowell, we're going to be setting up a time for a hearing on whatever motions are filed, okay? So you'll need to stay in touch with Mr. Bennett and find out when we schedule it so that you can be here at the next date. Okay? Okay.
May I
Yes.
address the clerk for a moment? Previously, there were 2 motions for funds allowed that I did not receive a copy of the allowed motions that was...
I will email them to you.
Thanks so much.
Great.
Okay.
All right, thank you, Counsel.
Okay, thank you, Ron.
All right, Mr. Dowell, we'll see you.
Thank you.
2 hearings from now.
Thank you, Madam Clerk.
Thank you. Returning to number 8, Commonwealth versus Robert Sampaio, 23 CR 237. Mr. Sampaio is present, along with, I think, standby counsel, Robert Nelson, Amanda Mullaney for the Commonwealth, and John Cannon for probation. It's on for probation report. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Amanda Mullaney for the Commonwealth.
Okay.
John Kiernan, Norfolk Superior Probation, Your Honor. Good afternoon.
Robert Nelson for Mr. Sampaio.
Okay. Mr. Kiernan, what's the issue?
So, Your Honor, since the conditions were put in place, Mr. Sampaio did end up going to Rhode Island and clearing the warrant in Rhode Island, but also picked up some new court dates, including the fact that he's on probation in Rhode Island. Being that he's on probation here as well and has a number of conditions to abide by, including not leaving the state and that he's on GPS, I would look to at least modify the conditions to allow for him to travel to make those court dates because at this point, my understanding is he's got a November 19th date, a December 2nd date, and a 12/9 date in Rhode Island. He also reportedly has some issues in Florida as well. I did reach out to Florida, and they did mention that they were interested in clearing up the warrant there in Florida. So, which brings us to another issue, whether or not that would be something he'd be allowed to do, given the conditions here in Massachusetts. So I'd want the court.
Okay, well, we knew about the Florida case, and I think I was told that the information that we had was that Florida wasn't interested in coming up here to get him. Obviously, it seems like we should modify the release conditions to allow Mr. Sampaio to travel back and forth to Rhode Island for purposes of the Rhode Island court appearances. Is there any objection to that, Attorney Mulaney?
No, Your Honor. My only concern would be Rhode Island is a point in the case where there is a witness as well as the victim who previously worked and may work again at a club in Providence. So I don't know if maybe it would be expeditious to make that an exclusion zone since he is going back and forth through Providence. But other than that, I have no objection.
Okay. Mr. Sampaio is going to court and leaving the state after court. That's what he's doing in Rhode Island, okay? I'm not authorizing him to stop off at 7-Eleven to pick up a candy bar in Rhode Island on his way back from court, okay? He's to go down to court, do what he has to do in court, and then come back to Massachusetts. That's the extent of my authorization for him to travel to Rhode Island. But that'll be a modification to the release conditions or the probation conditions so that he can appear for his Rhode Island court appearances, okay?
So may I suggest that the amended conditions read allowed travel to Rhode Island? Do we want to not include Florida in the situation?
We're about to talk about Florida. We haven't talked about Florida yet.
Sorry.
Okay? Does Florida want to come up and get Mr. Sampaio?
That I do not know.
So the question is whether there should be an authorization, Mr. Sampaio, to go down to Florida to clear up the warrant down there. Seems like it's in his interest, and it's in everybody's interest, that he clear up the warrant in Florida. Last thing you want is for him to be picked up off the street here because somebody from Florida comes up here or seeks an extradition, and the Massachusetts authorities cooperate with the Florida authorities to get him down to Florida. So it seems like we should authorize that on a date and schedule approved by the probation department. What do you think about that, Attorney?
I have no objections. Just to be candid with the court, I will say that I spoke to Florida. It was a while ago. It was about a year ago, the first time we lobbied it. They did want him and indicated they would be willing to come pick him up.
Okay.
I don't have an objection to a recog at this point. He went to Rhode Island. He cleared all of his warrants. The victim has no connection to Florida.
Okay. So the question is a recog to Florida. Mr. Sampaio is going to have to get down there. You're going to have to get to the courthouse. I don't know which court.
Miami-Dade.
Is it Miami-Dade?
Fort Myers.
Oh, Fort Myers? Okay. Other coast, right?
The Lee County Sheriff's Office, Your Honor, Fort Myers.
Okay. So what kind of schedule makes sense, Mr. Nelson?
And just speaking to him, he indicated that maybe sometime within the next 2 weeks.
That makes sense.
If I may, Your Honor,
Sure.
It wouldn't be just Fort Myers as well, because John also has the other paper for my license. I have to clear that up. That would be in Broward County and Dade County as well. So it'd be
Broward County is the other coast.
Exactly. So I'll be on Fort Myers, I'll be in Broward and Miami. So it will be a lot of traveling in Florida as well. Just want to keep it clear. I'm not just staying in Fort Myers.
But we only have a detainer or a warrant from one location, right?
Correct.
That's Fort Myers.
That's Fort Myers, that's it.
All right. So what I will do is I will give We'll issue a recog for you to go to Florida to clear up the warrant. We'll make it good for 2 weeks. Before leaving for Florida, you'll talk to Mr. Kiernan. He'll know when you're leaving, and he'll know what your travel arrangements are. He'll know where you're going to be staying, okay? And he'll know when you're coming back. So you can travel, but it's got to be on a schedule approved by probation.
Fine.
All right? And so stick around. We'll get you the recog. Any problem with that?
No.
Okay. Anything else, Mr. Kiernan?
No, Your Honor.
I don't know if, that's, no, has a problem.
Can someone email me like the court information and case number?
I can send the III, if that's helpful.
Is those are notoriously hard.
They're tough. Mr. Kiernan probably has the information.
I do.
I've just never done one that's open.
Yeah.
Weeks. Okay.
But just, Your Honor, just to satisfy probation, I can give you an amended conditions that state allow travel to Rhode Island, Florida for hearings and to address any warrants or probation matters with verification to mass probation. Does that sound?
Well, I want to make sure that you know in advance, okay, that Mr. Sampaio is going, okay? So it's not just with verification, it's that, you know, he notifies you before he goes to Rhode Island that he's going and when he's going, et cetera. And the same is true for Florida, okay? Prior advance notice and approval by probation. Okay?
So the 2-week date would be November 14th. So before November 14th, got to go to Florida and come back.
Right, that makes sense.
And your conditions of probation are being amended to permit you to travel to Rhode Island for court appearances with prior notice to probation, and that you may travel to Fort Myers, Florida. I don't know how to put Broward County.
I think it's sufficient to say he's permitted to travel to Florida to clean up the warrants.
All other conditions remain the same, and please be in touch with probation.
Yep.
Thank you.
Thank you.
Okay.
Thank you, Ron.
Thank you, Madam Clerk. Thank you.
Next before it's going to take me a moment to do that, so just, I have to grab paperwork downstairs. Next before and can you send me email me the court information?
I can give it.
Okay, great. Next before the court, number 14, Commonwealth versus Daniel Steele, 25 CR 112. Mr. Steele is present along with his attorney, William Keefe. The Commonwealth is represented by Assistant District Attorney Joseph Martinelli. Matters on for pretrial conference. Do you mind if I run down?
No, we can do 7 next, too.
Okay.
Okay, counsel?
Yeah, good afternoon, Your Honor.
Okay. Oh, I see. No, I know, but we may be continuing something else.
Okay.
Okay?
Sir, on the matters on pretrial, it involves a search warrant. We did have a conversation about if counsel wanted a filing date for the motion to suppress on the search warrant, and we're also in talks about potentially resolving the matter, and counsel's going to get me some documents related to that end. So I think we're just seeking a filing date for a potential motion to suppress on the Four Corners.
Okay. Is that right?
That's correct, Your Honor.
What do you want to do a Four Corners motion for if you're going to, and put all that effort into it, if you're going to try to resolve the case?
So, that's a good question.
It's
sort of moving the case along. I have to get this breakdown packet to Mr. Martinelli. So I'll defer to the court as for the next event. Just in case we weren't able to resolve it, then maybe that would be progress.
All right. How long is it going to take you to get the packet to Mr. Martinelli?
3 weeks.
All right. So why don't we put this on, you think of an in-court filing date? Can you get the motion on the Four Corners motion filed by the end of November?
Yes.
All right. So why don't I say an out-of-court filing date would be the end of November.
November.
Yeah. Or we could use that date as a date for lobby conference if you think that's going to be enough time to get material to Mr. Martinelli.
That could be an out-of-court, Your Honor. I'm out of town for the Thanksgiving.
Okay, all right, so that's Thanksgiving. I'm sorry to do that, November 28th. That's a crazy time. Why don't we say December 3? So it would be December 3 for an out-of-court filing date for motions. And why don't we put it on for December 12 for hearing on motions or disposition?
Perfect.
That's fine, Your Honor.
12/12?
Which type of motion? I'm sorry.
It's a Four Corners suppression motion, which would be filed out of court December 3, but 12/12 might be a resolution of the case, and it might be a hearing on those that motion.
Yes, sir.
Okay?
9 o'clock, Your Honor?
For which? 12/12?
12/12.
No, it doesn't sound like your Four Corners is going to require evidence, so we could do that at 2.
2 o'clock.
Yeah, 2 o'clock.
Mr. Steele, we'll see you, December 12th at 2 o'clock for hearing on your motion to suppress. Thank you.
Thank you, Your Honor.
Okay.
Thank you, Ms. Chanel.
I don't know.
Next, before the court, number 7, Commonwealth versus Jeffrey Comoletti, 23 CR 231. Mr. Comoletti is present and represented by Attorney Karen Wayne. The Commonwealth is represented by Assistant District Attorney Michael Gaffney. The matter is on for final pretrial conference, and parties indicate there might be a plea as to count 2.
I can't tell from this.
I'm still not crazy.
No, I can't tell from this. Sorry.
That's okay. The parties could please identify themselves for the record.
Good afternoon, Your Honor. Michael Gaffney for the Commonwealth.
Okay.
Good afternoon, Your Honor. Karen Wayne on behalf of Jeffrey Carmelotti, who is here at the bar.
Okay, Mr. Comoletti? Okay. So, we have a trial, jury waived, starting on Wednesday, right? And I got a motion to continue. Looking to put at least part of it over to December.
I believe it's scheduled for Tuesday, Your Honor.
Tuesday, I'm sorry.
And I would object to that, Your Honor.
You'd object to what?
I would have to putting it over. My brother and I have talked extensively about this, and he can explain to you what his plan is, about having his chemist testify at the end of November, which puts me in a bad position because I have a Superior Court jury trial starting here September 3rd.
December 3rd or?
December 3rd.
Okay.
And another one you just assigned the other day on December 16th. It's not fair to me to have 2 jury trials almost back-to-back, plus a bench trial, because I had to put my side of the bench trial on in between those 2. My client deserves my full attention to his trial, and I think this is bordering on malpractice on my side. And if I remember the last time we were here, you were very specific with my brother as that FMLA does not stop him, the chemist, from testifying. The letter that I got...
What case do you have in this court on the 16th?
Mr. Ba, B.A.
Oh, Mr. Ba, okay. You said to me when we scheduled that was almost surely going to be a plea. That was definitely going to be a plea.
He changed his mind.
All right. Well,
because of immigration issues, so I think we're going to end up going forward with the trial on that one.
okay. Well, we might have to move that case a few days later. Anyway, we'll see.
I just wanted, because you were very clear the last time. The only thing the letter states is that he can't work. It doesn't state the reason why, and maybe for personal reasons they can't do that. But it's just so unfair to have my brother put his portion of the trial on November 4th, and then I can't do my case until way after the 28th of November. That's a big gap. And plus, I have that jury trial, it's either the 2nd or the 3rd, I forget the day, for Mr. Grant.
That's the 2nd.
2nd, yeah.
Okay, Mr. Gaffney, what do you say?
Well, first of all, Your Honor, I believe we reached an agreement on a change of plea to count 002, which would greatly shorten the witness list.
Great, we'll do that just before trial.
Okay.
Okay.
Well, we were thinking of, taking the plea today, Your Honor. Because along with taking the plea, Mr. Carmelletti gets the GPS off, which he's had for a long time. So we were hoping to do that today.
I have 5 witnesses scheduled to be in the courthouse at 9 a.m. on Tuesday that do not include any witnesses that have to do with count 2.
All right, so here's the problem, okay, I do not want to schedule this, with a month in between. That's crazy.
Well, I did file
and I saw your supplemental filing, okay?
I also filed a motion to continue as amended.
I beg your pardon?
I filed two items yesterday. One was a motion to continue as amended, a general continuance for the whole case, other than count 2. The second one was if that was not going to be allowed by the court, the supplement to that was my suggestion to do a bifurcated trial. I'm ready, willing, and able to do all the witnesses with respect to the investigatory part of the case. I have no way of proceeding without my chemist, who's not going to be available till after November 28th. So I suggested, especially with no jurors being inconvenienced, that may be an appropriate way to go. But I did file a general motion to continue with it.
This is jury waived.
Yes.
We can put this on for a jury waived trial in December. Okay, I know, you're shaking your head.
No, it's impossible, Judge. I'm only one person. I can't do 2 jury trials and a bench trial in 1 month. That's just unreasonable. Can't do it.
When is your chemist available?
After November 28th.
Can't change it. Whatever he's going to do, he's going to do.
Well, we can put this on for a jury trial in January, first week of January. A jury waive trial, first week of January.
You know, the only thing I don't understand, I asked for a continuance, and you denied it because I had 5 months. I didn't put a lot in my motion that you should have known because it was personal to me. So I didn't put a lot in that motion, and I think if I put everything in that motion, you probably would have granted me a continuance. But yet the Commonwealth has the same 5 months to know that this person was not available. I'm thinking, or close to it, and that's what you had stated. We all both had the same 5 months, and I'm asking you not to continue the case.
All right, that request is overruled.
Okay.
Do you want a trial in January, or do you want a trial in December? I'm happy to give you a trial in December.
I can't do it in December.
We could do the 22nd of December.
No, I can't, Judge. I can, 2 jury trials is enough. That's exhausting enough. I can't do it in December. I can do it in January. But I'd like to take the plea today if we can.
I'm not going to bifurcate everything here. We'll do the plea before the trial.
Okay.
And, or we can set up I suppose we could do the plea. We want a plea and sentence Mr. Carmelletti now?
It's just a 2 years probation, Your Honor. It's an agreement.
And if Mr. Carmelletti gets convicted of the other offense, is the probation going to be stayed during any period of incarceration?
That's my request.
All right. Has your client entered completed a waiver of rights form?
Yes.
Okay. Do we have other matters that we need to get to that?
Just recalling Walshe.
Uh-huh.
And I believe that's it.
I want to get this off of you today. That's
Yeah.
Okay. The problem with my taking the plea now, I guess there's no problem with me taking the plea now. I was thinking that I'm not going to be here in January to do the trial, so somebody else is going to be doing the trial, but I don't think this sentence is going to impact that schedule. So, all right. In terms of a date for trial, let me just see, trial schedule.
I do have a Superior Court jury trial that's supposed to go on the 13th of January.
Well, I was thinking January 6th, but there are a bunch of trials that are actually on for jury trial on the 6th.
Right.
The 13th is even worse.
And the 13th is worse, yeah.
Yeah. I couldn't do two, so. And the 19th is a holiday, so. I was maybe the 26th, so.
How long would it take to try this case? Jury waived, 2 days?
I think it would be,
Or 1 day?
I think it would be 1 day, if we get the chemist in, without the count two.
So what I'm thinking of is we do January 9.
That's a Friday, Your Honor, that's fine.
It is a Friday.
It's a Friday. It may go over, because the Commonwealth may put their case on 1 day, and I still have my experts. So maybe more than a day, Michael, don't you think? Maybe.
Okay. All right, so we'll put count one on for a jury waive trial on January 9. And we'll take the plea on Mr. Camilletti on count 2. Now, I believe so, yeah. Let me see. Yeah, let me grab it for you. Mm-hmm. Okay.
May I inquire?
Please.
Mr. Camilletti, how do you now plead to indictment number 2382CR00231, offense 2, charging with possession of explosive device or substance? Guilty or not guilty?
Not guilty.
Please raise your right hand, sir. You solemnly swear or affirm that you shall make true answers to any such questions that are put to you by the court in the matter now in hearing, so help you God.
I do.
Thank you. Waiver of rights has been executed.
Okay. The offense of possession of explosives, what's the maximum penalty for that?
Your Honor, the maximum penalty is not more than 2.5 years of house of correction, or if a state prison sentence is imposed, not less than 10 years, no more than 20 years.
Okay. Did you hear that maximum penalty, sir?
Yes.
Okay. Mr. Camilletti, why don't you have a seat? Just pull that microphone down so that you're speaking right into it. Would you state your full name for the record, please?
Jeffrey Camilletti.
Okay. And do you have any difficulty speaking or understanding English?
Nope.
Okay. Before I can accept your plea to this charge, I have to ask you a series of questions. If there's anything in my questions that you don't understand, I want you to stop me and I'll explain it, okay?
Yes, I understand.
Okay. Mr. Camilletti, how old are you?
56.
56?
Yes.
Okay. Natalie, do you have a carry? Thank you. And what's your date of birth, sir?
March 22nd, 1969.
Okay. How far did you go in school?
Part of almost got an associate's degree, a few classes away.
All right. Are you married or single?
More single.
Okay. Do you have any children?
Yes.
How many kids do you have?
2 boys.
Okay. And what do you do for work?
I retired from the Norfolk County Sheriff's Office, and I do masonry work for my own business. I'm on the side.
Okay. Have you ever been treated for a mental illness or condition?
Not a major one. I've I had ADHD since I was a child, that's all.
Okay, and do you take any medication for that?
Yes.
What do you take?
Adderall.
Okay, and the Adderall that you take it at the dosage prescribed for you by a doctor?
Yes.
Okay, and how does that make you feel?
Just normal.
Okay, do you feel like your mind is clear today?
Very clear.
Okay. Have you gone over well, let me ask you this, Mr. Camilletti. Have you had anything to eat or drink, drugs, alcohol, or anything else today that would interfere with your ability to understand what's going on here today?
No, Your Honor.
Okay. Have you gone over with Ms. Wayne what the Commonwealth would have to prove in order to prove you guilty of this offense?
Yes, I have.
All right. You heard the maximum penalty, right?
Yes.
Up to 20 years in state prison.
Yes, I did. I heard it.
And a mandatory minimum in state prison of 10 years if you're sentenced to state prison. Did you hear that?
I did hear that, yes.
Did you hear that there's an option of up to 2.5 years in the House of Correction?
Yes, I heard that.
All right. What you have to understand about those maximum penalties is if I do impose a period of probation on you and you're later found to be in violation of your probation, that is to say I or some other judge finds you in violation, the judge who finds you in violation can sentence you up to that maximum statutory punishment of 20 years. Do you understand that?
I do.
Understanding that risk, do you still want me to accept your guilty plea to this charge?
Yes, Your Honor.
All right. By pleading guilty, you're giving up quite a number. You understand also that I'm not a party to your agreement with the Commonwealth to recommend a sentence of probation. I don't know what I'm going to do yet. Do you understand that?
Yes.
And if I accept your plea of guilty and I decide not to sentence you to probation, you can't retract your plea. You understand that?
I understand.
All right. By pleading guilty, you're giving up quite a number of constitutional rights that protect you in this case. You're giving up your right to a trial. Do you understand that?
Yes.
Do you understand you have the right to a trial with a judge or a jury to determine your guilt or innocence?
I do.
You understand if you opted for a jury trial, a jury would be 12 people selected at random from Norfolk County. You and your counsel could participate in selecting the jury, and the jury would have to be unanimous. That means all 12 people would have to agree that the Commonwealth had proved you guilty before you could be found guilty. Do you understand that?
I understand.
Do you also understand that at a trial you have no burden? The burden would always be on the Commonwealth, and the Commonwealth would have to meet the highest burden the law sets, which is proof beyond a reasonable doubt. Do you understand that?
I understand.
Also, at a trial, you wouldn't have any right to, you wouldn't have any obligation to testify. You would have the right to testify, but no obligation to testify. You could remain silent, and if you stayed silent, we would tell the jury they couldn't construe anything against you because you chose not to testify. Do you understand those things?
I do.
Do you understand that at a trial, you'd have the right, you or your counsel, to cross-examine the witnesses called by the Commonwealth to testify against you, and you'd also have the right to call witnesses on your own behalf, and if they wouldn't come into court voluntarily to testify for you, you could ask the judge, and the judge would order them to come in. Do you understand that?
Yes.
Do you understand that by pleading guilty, you're giving up your right to challenge the admissibility or seek to exclude evidence that the Commonwealth might use against you in this trial? You may have filed a motion to suppress or exclude evidence, I'm not sure, but in any event, by pleading guilty, you're giving up your right to challenge the admissibility of evidence, seek to suppress or exclude evidence, both here and on appeal. Do you understand that?
Yes.
Understanding all these rights that you're giving up, do you still want to plead guilty to this charge?
Yes.
All right. Mr. Gaffney, if I could ask you to describe what the evidence would be if the case went to trial with respect to this charge, that would be great. Mr. Camilletti.
Your Honor, with us.
Wait. Are you all set, Ms. Wayne? Mr. Camilletti, I'm going to ask you to listen carefully to what Mr. Gaffney is going to say, because when he's done, I'm going to ask you if you did the things that he is about to describe, okay?
Okay.
All right. Go ahead, Mr. Gaffney.
Thank you, Your Honor. Your Honor, count 2 of this indictment to go to trial. The Commonwealth would present evidence that on April 28, 2023, officers from the Weymouth Police Department, U.S. Postal Inspection Service Task Force, State Police and Drug Enforcement Administration executed 3 search warrants, 2 of them for packages that were delivered in the mail that day, and 1 for Mr. Comaletti's residence at 101 Mansfield Street in Weymouth. With respect to the search warrant that was executed for the residence, which comprises the count two of the indictment. The state police bomb squad assisted in the execution of the search warrant. During the search, a small plastic container was found in the living room with a white powder substance and metal flakes inside. Bomb squad officers tested this powder outside, and it came back positive for explosives. It was packed up, and the explosive material was delivered to the Trace Arson and Explosives Unit of the State Police Crime Laboratory. There are two items submitted. The first one, examinations indicated and identified a mixture of magnesium, sucrose, potassium nitrate, and a low explosive double-base smokeless powder. Magnesium and or sucrose in combination with potassium nitrate is a fuel oxidizer mixture. A double-base smokeless powder is a low explosive propellant principally used in ammunition and homemade devices. These items in combination become an explosive substance. Not an explosive device, but an explosive substance also covered by the statute. The second submitted item indicated and identified magnesium, which by itself is not an explosive substance, but is a precursor to an explosive substance.
Okay. Did you hear what was just described?
Yes, I did.
Okay. Did you do the things that were just described?
Yes.
Okay. Is there anything important that's different from what was just described that you need to bring to my attention?
No.
Okay. Are you pleading guilty to this charge willingly and voluntarily?
Yes, I am.
Has anyone forced you or threatened you in any way to get you to plead guilty to this charge?
No, they haven't.
Has anyone promised you anything in exchange for your plea of guilty to this charge other than the Commonwealth's agreement to recommend a particular sentence to the court?
No.
Okay. Have you had enough time to discuss this case, and this charge, and any defenses that you have to this charge with Ms. Wayne?
Yes, I have.
Have you gone over your rights with her and the consequences for you of pleading guilty to this charge?
I have.
Do you feel like she's acted in your best interest through this case?
Yes, she has.
I have a waiver of rights form here. It's in English and in Spanish. On the first page, it says Jeffrey Camaletti at the top, and about a third of the way down on the second page, it has your name, today's date, and the signature in green ink. Is that your signature, sir?
That is.
Okay.
Yep.
Did you read at least the English portions of this form before you signed it?
Yes.
Did you understand it?
Yes.
Did you go over it with Ms. Wayne?
I did.
Do you have any questions for me about the rights that you're giving up by pleading guilty?
No.
Okay. I have to advise you that if you're not a citizen of the United States, my acceptance of your guilty plea to this charge will almost surely lead to your deportation. And if you're to be deported, you're to be denied readmission or excluded from the United States and denied naturalization as a U.S. citizen under U.S. law. Do you understand those things?
Yes, I understand.
Also, by pleading guilty to this charge, you'll be required to give a sample of your blood, hair, or saliva to the state police. They'll take a DNA profile from that sample and keep it in their DNA database basically forever. You'll be required to pay the $110 DNA fee for the cost of collection of that sample, and failure to give a sample if required is an independent criminal violation. Do you understand those things?
Yes.
It would also be a violation of your probation if you failed to give a sample if required. Do you understand that?
Yes.
All right. In Massachusetts, we have something called the habitual offender law, or three strikes law. And basically what that says is if you're convicted of a serious offense after 2 prior convictions for serious offenses, for that third serious offense, you have to be sentenced at the maximum permissible punishment, and you're not eligible for probation or parole or good time credit or work release or furlough or programs like that. Do you understand that?
I do.
And what you have to understand about this is if I do impose a period of probation on you or a period of incarceration of up to 3 years, on this charge, or if you're end up getting incarcerated for more than 3 years as a result of a probation violation, this could be one of those habitual offender predicate convictions, one of those strikes. Do you understand that?
I do.
Okay. Understanding everything we've discussed, do you still want me to accept your guilty plea to this charge?
Yes, Your Honor.
All right. Ms. Wayne, have you had any difficulty communicating with Mr. Camaletti since you've been representing him?
Not at all, Your Honor.
Have you gone over the elements of this offense with him?
I have.
Are you satisfied that his plea of guilty to this charge is entered knowingly, willingly, intelligently, and voluntarily?
I am, Your Honor.
Okay. It doesn't sound like there are any named victims in connection with this matter. Is that right?
That's correct, Your Honor.
Okay. All right. Mr. Camaletti, based on our discussions, I'm going to make certain findings. I find that you're not presently under the influence of drugs or alcohol other than medication prescribed for you by a doctor, that you've taken it at the prescribed dosages, and it doesn't prevent you from pleading guilty to this charge. I find that you report you're not presently suffering from any mental illness or condition other than the ADHD which is being treated, and that also does not impair your ability to enter a plea to this charge. I find that your change of plea to guilty with respect to this charge is made knowingly, willingly, intelligently, and voluntarily in full knowledge of the consequences for you of pleading guilty. I find that your plea is made on the advice of competent counsel, Ms. Wayne. I find that there's a factual basis for you to plead guilty based on what Mr. Gaffney said here in open court on behalf of the Commonwealth. And I find that you understand that if you're not a citizen of the U.S., my acceptance of your guilty plea will almost surely lead to your deportation. I will accept your guilty plea to count 2 in docket 23231, and I'll hear from the parties with respect to disposition.
Your Honor, this is a negotiated disposition, but in all the time we've been discussing a disposition on the whole case, this was always the agreed upon, or at least the Commonwealth's recommendation on count 002, that this is anticipated that this probationary period would commence upon the conclusion of the whatever happens on count 001. I believe.
I'm sorry, would not start now?
I would ask that it be stayed until such time as count 1 is litigated, and there's either a sentence imposed or it's a not guilty, because the intention is for it to run from and after a release, if convicted, or if not guilty, from that day forward. Otherwise, I suggest it's relatively meaningless to start and run now, but on that, I will defer to whatever the court thinks is best.
So I have the authority to impose a probation period to start to run at some future date where there's a big gap. I mean, I can run it from and after an incarcerative sentence, but I don't know if I can start a probationary sentence from some period down the road. Well, I don't even know if there's going to be an incarcerative sentence.
Nor do I, but I think Your Honor has the power to stay the execution of the probation to a later date.
Okay, Attorney Wayne, you got any authority for me?
Yes, Your Honor. As you can see, Mr. Carmelletti really doesn't have a record. He has a clock for 3 months on there. He abided by all the probation, and that was dismissed. He's been very good on his pretrial release conditions. There haven't been any issues. My brother did agree to remove the GPS. This was the charge. I think you told me that really the GPS was put on for, but now that it's fled, he's agreed to remove the GPS. So I'd ask you to adopt the 2-year probation. I thought myself too, it needs to start today, but I'll just defer that to the court.
Does the Commonwealth propose any conditions on the probation?
Just the general statutory conditions, Your Honor.
What are the current probation, pretrial release conditions?
He has a curfew from, I think it's 9 at night to 7 a.m. in the morning. Mm-hmm. He does have drug testing because of the drug charge. That's still going on, random drug testing, and the GPS. That's all you have, right?
Yeah, that's it. Yeah.
That's it, yeah.
And I have the docket from the district court where they were first imposed.
Right. So I think it was a result of a 58A, but I could be wrong. I came in later.
Well, this was GPS home confinement, no alcohol or drugs, possess no firearms or explosives.
Right.
So this is GPS, this is not curfew.
Well, he has a curfew, Your Honor. We worked through it. My brother's been very generous to allow.
I'm just trying to nail down exactly what the conditions are.
If he's not now, he has 9 p.m. to 7 a.m. so he can work during the week. And we just changed that to...
All right. I am far more concerned about the long sentence that Mr. Camilletti could receive on trafficking more than 200 grams of cocaine.
Well, that's yet to be seen, Judge, so we don't...
Oh, it's very much yet to be seen, but it's pretrial on that charge, and I'm not inclined to change those conditions.
Oh, Your Honor, Commonwealth's position is those conditions remain in place as long as count 001 is pending, except for I've agreed to council's request that the GPS be removed.
Everything else is in place.
All right. And you are suggesting a period of probation of how long?
2 years, Your Honor.
Okay. All right. Mr. Camilletti, before I impose sentence on this charge, if you want to say anything, you can. You don't have to say anything if you don't want to.
No.
Okay. Mr. Camilletti, if you could stand, I am going to impose the 2-year probation sentence. It's going to begin to run now. It's going to be stayed during any period of incarceration that you receive on docket 23231, count 1. I don't know if you're going to get a sentence on that count, but if you do, the probation will be stayed. The probation will only be subject to the standard conditions of probation. I'm not going to add any probation conditions, except that you remain drug and alcohol free. I'm not going to impose the random drug testing condition. Those conditions, though, remain in effect as your pretrial conditions, both the curfew, the GPS, and the drug testing. Okay, I am not going to lift the GPS, I'm not going to lift the curfew, and I am not going to lift the random drug testing condition while that count 1 is pending, given the length of the mandatory minimum that Mr. Camilletti would be facing on that charge. There is a victim witness fee of $90, which would be a condition on the probation. There's a DNA fee of $110. There's a legal counsel fee of $150, and those will be assessed over the course of probation.
You want to, just to clarify, because I thought you first said that he is to remain drug and alcohol free, and then you eliminated the random testing, and then you changed it. I'm not sure if I heard that correctly.
Let me be real clear, okay? On the probation,
okay,
there's a condition that Mr. Camilletti remain drug and alcohol free, and there is no random testing condition.
Okay.
But the pretrial conditions remain in effect.
Okay.
The existing pretrial release conditions remain in effect as to count 1.
Okay.
We discussed having a trial. The trial will be held on January 9, 2025, jury waived. Okay?
So, Mr. Connolly, the court having accepted your plea of guilty to offense 2, charging with possession of explosives, in consideration of this offense, the court places you on probation for a term of 2 years, which will start today. As a condition of your probation, you remain drug and alcohol free. All of your conditions of release remain the same as to offense 001. Your matter is continued to January 9th for a jury waived trial at 9 a.m. as to offense 001. If you would just check in with probation before you leave today.
Okay.
Thank you, sir.
Does he sign the conditions with you, Hunter, or does he have to go across the street?
Thank you, Your Honor.
Okay. I'm going to get off the bench for just a moment. Okay. Yeah. So long as conditions, so long as no fund. Then it says that has to count 001. This is all previous conditions remain. No, I don't need that. Thank you. Okay, thank you.
All right.
You're welcome, thank you. Oh, will you mute? Yeah, this is my phone. Please.